The first step in this process is filing a petition for dissolution. As I mentioned in the intro, dissolution is just the court's way of saying a divorce. There are two ways that you can go about filing. The first is called a single filer. That's when one person from the marriage goes to the court and files the petition by themselves. They're asking the court to grant a divorce. In that case, the person filing the petition would be called the petitioner. The other person in the marriage would be called the respondent. They will eventually have to respond to the petition for divorce and respond to the court. When there is a single filer, there are issues of service, essentially meaning if one person files with the court a petition, they need to formally have the other party or respondent served with the petition and other paperwork so that they are aware that there is a formal court proceeding that might involve them or their interests. Until service is established, it cannot go forward. So in a single filer, service is incredibly important. I will cover that in the next video. The second option for filing for divorce would be if both people from the marriage together go down and they file one petition for dissolution together. In that case, they would be called a petitioner and a co-petitioner. They are both asking the court to grant a dissolution. They're both petitioning the court to hear their case. In this case, because they're both going together, they both sign the petition and submit it to the court. It tells the court that both parties are aware that this is happening and there's no need to worry about service. The court's main concern in this is that everybody knows that something is happening at the court involving them. So, single filer, there might be some service issues. In a co-petitioner situation, no service issues. Either way, both parties have a couple of requirements that they have to follow to determine where to file and how to file and all that kind of stuff. So there are three main things to know about filing requirements. The first thing is one of the parties must have lived in Colorado for at least 91 days before filing the petition. That means if you lived in North Dakota up until 30 days ago and your other spouse and the other spouse also lived in North Dakota up until 30 days ago, you cannot file in the state of Colorado. There is not proper jurisdiction. You have to wait until you have lived in Colorado, you or the other party has lived in Colorado for 91 days. It doesn't have to be both of you, it just has to be one of you. So first, has one of you lived in Colorado for at least 91 days prior to filing? The second issue is determining what county to file in. So you either file in the county that you live in or the county that your spouse lives in. If you live in the same county, obviously it's easier. But if you live in different counties, I would say determine, which one is easier to get to, which one is your spouse more likely to show up to, things like that. If you have kids, there is a little bit more to it than that, and I will explain it in the video covering children. But if you don't have kids, you either file in the county that you live in or that your spouse lives in. The third requirement for filing is there will be filing fees. The person who files the petition will have to pay, and if you're a single filer, so the petitioner pays, and then the respondent, that's the second party, who will have to respond to the petition within 21 days of filing, will also have to pay a response fee. If you're co-petitioners, then you pay your fee at the same time when you file. Any way you file, whether it's together or not, everybody ends up paying a filing fee. There are forms that the clerks or the self-help center can help you get if you're looking for a reduced fee or a no fee. Alright, so 91 days in Colorado. It has to be in the county that either you or your spouse live in, and there will be filing fees. So the last important thing you need to know about filing is there are several things that you file at the very beginning. So the first one is called the Case Information Sheet, and that is JDF 1000. All court forms start with JDF, and then they have a number after it. So you can search on the website, and I can show you how right here. You can search on the website self-help forms. And you just put in whatever number you want to search for, and it should pop up right there. Alright, so we're starting with JDF 1000, the Case Information Sheet. This will be the first sheet that they have you fill out. This is the caption form, which will be on every single thing you file with the court. You put the address of your court in your county, and in this case for a divorce, you would mark in re the marriage of, the petitioner's name, and then either the co-petitioner or respondent's information. They will give you a case number to put here at the time of filing. So this case information sheet is very basic. Everybody's name, date of birth, your address. This is so the court knows how to contact the people in the case. And then it'll be the same for the other party. You do fill this out to the best of your knowledge for the other party. Then it also asks for information about if there are any children of the marriage. You put that there. The last thing you mark is if you plan on being represented by an attorney. This is just at the moment. It can always change. Say you're represented by an attorney in the beginning, but then change your mind at the end. That's fine. Vice versa. This is just at the moment you're filling it out. Do you think you'll be having an attorney or not? Then you sign. If you're filing together, you both sign. And that's the case information sheet. The second form that you will have to file at the beginning is JDF 1101, and this is the actual petition for dissolution. So, again, address, you put names here, and they'll give you a case number. If you're filing for a legal separation, you would click here. If you're filing for dissolution, obviously here, and indicate if there are kids. One thing you'll notice about court forms is they repeat themselves a lot. So you once again fill out your basic information about address, date of birth, that kind of stuff. Same thing for the other party. This is where you're going to put the date of marriage, where you got married, and the date you separated, to the best of your knowledge. If it's a month, that's okay. This is where you indicate if someone is currently pregnant or expecting a child. That's important for the courts to know. And again, information about the children. This is where you indicate if any of the children involved have, if they are or their relatives have American Indian, Native American, or Alaska Native ancestry. There's a different legal process if that is part of your case, so make sure to indicate there. It's also important, if you do have kids, that they've lived in Colorado for 182 days before filing the petition, or since birth if they're under 6 months. And again, I can explain all of that in more detail in the children's video, but go ahead and indicate if that is the case or not. This right here is asking you if there's any other case involving your children that might affect your current dissolution case. So you need to put that information here, the court, the case number, what state it's at. This is asking, are there any other cases involving the two married people that might affect it. Is there a domestic violence case, a protection order case, that kind of stuff? You would indicate that here. This is saying, is there anybody else who's not part of the marriage but have current physical custody or might have a claim over the children? A grandparent, an ex-spouse, something like that. You put their information there. If you are receiving benefits or public assistance from the State Department of Human Services or the County Department of Social Services, you would need to indicate who's receiving it, the county, state, your case number, information there. Is there a protection or restraining order involved in the case? Obviously, the court will need to know that. Fill that out if there is, or mark no if there's not. Do you have an existing case with child support enforcement? Also important for the court to know. Indicate yes or no there. This is just saying we ask the court to enter orders. In this case, it'd probably be status of marriage if you have kids. Most people just check all of them. And then if anyone is requesting a name change back to your prior name, it's not any name change, it's just to your prior name. All right, once that's filled out, this is signed by the petitioner. And if you have a co-petitioner, this is where they sign. Again, if you're single filer, only one person files. If you're co-petitioners, both people will file. The last form that you need to be aware of would then be the summons. That's JDF 1102. And this is if there is a single filer. This summons is basically summoning the other party to the court, saying there is a court case involving you or your interests, and you need to come to the court so you can file a response. It explains all of that there for them and kind of what they need to do. So it's all just basic information for them, and that would be sent to them as part of their service package. Again, this is if it is a single filer. The last form that you might get at the time of filing is called a CMO, or case management order. That's given out by the court. It's just kind of an overview of the process, maybe some terms that you might need to know, or some dates and that are going to be important to your case. So overall, you will be filing that case information sheet, the petition, and if you're a single filer, the summons would all be part of your initial filing package. The summons will I'll also address in the next video about service.